Okay, we're going to get started. So welcome to this session. I hope you've had a good start to your morning in previous sessions. You are in session 9C, Innovating for Impact, New Models of People-Centered Justice. And welcome. My name is David Wiseman. I'm a professor at the University of Ottawa Faculty of Law, and I'm just moderating this session. And we're delighted in this session to be joined by 5 people for the purposes of 4 presentations. We're going to go through the presentations in the order that they appear on the screen there. I will only do the briefest of brief introductions of each of the speakers, and then we will cycle through the presentations and have hopefully be able to hold some time for questions and discussion at the end. The first presentation will be from Jamie Maclaren, who's sitting immediately to my left, and Jamie is the Executive Director of Access Pro Bono Society of BC. Then the next presentation will be a team presentation between Leah Morris and Katherine Haist of the Advocacy Centre for Tenants of Ontario, and Leah is a social worker at ACTO, and Katherine is a lawyer at ACTO, and they'll be speaking about a program they work on together. Then the third presentation will be from Bérangère Desfonds, who's with Justice Pro Bono, and Bérangère's presentation, the slides will be in English, but the presentation will be en français. And then finally, to my far left, Dolapo Asaju, who is a program manager at Jaku Kombi, which is, or Kombit, Jaku Kombit, which is a community-based organization serving the African Canadian Black and other Black communities in Ottawa, and she'll be talking about the Black Justice Navigator program that she's working on there. So, allons-y. Up to you, Jamie.
Hello everyone, bonjour tout le monde. Je m'appelle Jamie. Je suis très heureux d'être ici aujourd'hui parmi vous. Je veux d'abord remercier David puis Véronique pour organiser cette panel. So, thank you very much, everyone, for having me here today. I'm going to talk to you a little bit about serving the missing middle and using data and innovation to advance people-centered justice in British Columbia. So when we talk about the missing middle, we often talk about an affordability gap, and these are people who, generally speaking, may include many of us here today, but can't afford market rate legal services, but don't qualify for many free legal programs or legal aid either. And there's millions of course, middle income people across Canada, and as a population, it's largely underserved and understudied. They face many of the same critical legal problems as low-income people who are typically, I won't say, well, served by free legal programs, and these can be problems like child custody matters, eviction from the family home, missing out on severance after wrongful dismissal, and so on. Really important legal issues. In our experience at Access Pro Bono in British Columbia, they make really good use of legal information. They have good access to free legal information and education, and increasingly advice from AI offerings. But they often seek to supplement that with the expert judgment of a legal professional, and that's when they approach us. So in a year, Access Pro Bono receives requests for legal help from about 80,000 people, which is a lot, quite obviously, and about half of those folk who approach us for legal help would qualify as middle income or the missing middle, and they don't qualify for our pro bono programs. Our financial eligibility criteria for pro bono is $65,000 for an individual, so pretty high, I think, among free legal service programs, all the way up to about $90,000 for a family of 4. So, you know, we when we talk about middle income, I think it truly is middle income, and maybe in some categories or in some cases upper middle income. The 5 largest areas of unmet legal need are the same as we see it for our pro bono programs: are family, civil disputes, employment, wills, estates, and housing. Many middle-income people, of course, are renters, especially in the large urban centers in British Columbia, like Vancouver and Victoria and Kelowna, and so they face, you know, tenancy issues from time to time. So adopting a people-centered lens, what kinds of legal help are needed? These are the questions we ask. What are people willing and able to pay? And how well is emerging tech meeting their expectations? Are traditional legal practice models up to task? And one of the more important questions, of course, is what are they able to pay? Because, of course, we can't extend to them free legal services. We struggle to meet the incredible demand for among low-income people, and so we've tried to craft some programs for them that offer them some really helpful legal services at a rate they can afford. So caller feedback, you know, these 40,000 people, they tell us that they're seeking legal help that is, well, first of all, I should say quality legal help. That's a given, you know, high quality legal help, but also timely, affordable, cost certain, and modular, or as we sometimes term it, unbundled. And we've developed 3 programs to serve this particular need. These are community responsive efforts, we think. And the first one is a legal referral service, which is a revamped or supplemented lawyer referral service, our Everyone Legal Clinic, and our Any Door project. So I'll quickly talk about those now. Our legal referral service is not new. It's been around since 1955. It has 1,700 lawyers, notaries, and paralegals having just joined. So in BC, is a quick digression, but in BC, we're likely to have a single legal regulator that regulates 3 professions at once, those being the lawyers, regulated paralegals, and notaries. And so we're trying to get ahead of that curve and include them all in our service offerings. And it's the largest lawyer referral service in North America, partly because it's been around since 1955, but because of the 1,700 lawyers. And what we offer them is a free, for people who call, free 15 to 30-minute consultation in all areas of law. Out of that, there's the expectation or the hope that the client will retain the lawyer. They'll come to an agreement around an affordable service to provide to the client. That doesn't always happen, of course, and you know, in the course of the consultation, the client or the caller still gets some legal advice about their problem. Our Everyone Legal Clinic is a part of the Law Society of BC's Innovation Sandbox, and it has certain allowances around the rules of regulation, but it's the only alternative to the traditional articling pathway in British Columbia. For those of you from Ontario, it has some of the characteristics of the law practice program, I think it's called. But it's much smaller, and it has different objectives, I think, and some different objectives. The one is we're trying to seed new legal practices in what are often termed legal deserts. These are underserved areas of the province where there are few to no lawyers serving community. And we prioritize the enrollment of people of color and equity-seeking people from equity-seeking backgrounds. And we also try and improve upon the classic articling experience and make it a really intensive, experiential, trauma-informed and program that provides that promotes a service that's culturally safe and responsive. And and we're also, so each of these students or clinicians, as we call them, are trained to sort of develop their own practice, at least for that one articling year, and they provide paid services to people in British Columbia at a very low rate, also at a fixed fee rate, and on an unbundled basis. The AnyDoor project is our newest, I guess, project among the three, and it's in recognition of the fact that people who call us, whether it's for pro bono service or one of these low-cost services, they often get stuck in what's a referral loop. I think we all know about that, where they approach different organizations, get told to go to another, have to retell their story, relive the experience in their minds that led them there, and often don't receive the service that they need. So this project is managed by us, coordinated by us, but it provides what we call warm referrals to other different organizations who are partnered. And it involves a two-way communications where we don't just tell someone to call another organization. We ourselves connect with that other organization, tell them a bit about the client's story, determine if this is suitable for help from that organization, and then broker basically or facilitate an introduction to that other organization. So it involves a bit more work, but it saves the client from basically cold calling different organizations seeking help and retelling their story. So this is nothing terribly revolutionary, but something we feel like if we can scale it up would be really helpful and responsive to client needs in the province. And we're trying to build it out as much as possible. Yeah, and this is my last slide here, but so it's not a common people-centered approach. I just meant to say that this is a people-centered approach that's common across these three different programs, although I suppose you could read it as common people approach too. Yeah, each program is experimental. These are the programs we've developed. They borrow from other previous programs and efforts across North America, certainly, but they're fairly new and innovative. We all try to be trauma informed. That's always a work in progress. I don't think you can always be fully trauma informed, but we do give our best efforts. It's iterative, it's constantly changing. Sometimes it changes and we adapt it to the funding levels we receive, and we scale up and down on that basis. And above and beyond other things, it's user focused. And so we're really trying to hear and listen to what our clients have to say to us. Oftentimes it's very critical. These are folk who are in crisis and have certain expectations, especially if they're paying any small amount for legal services. They come to us with real expectations, which is often augmented by knowledge they may have gleaned from AI and their own research, and so there's certain presumptions often at play. But we listen to everyone, and we certainly try to abide by the constructive criticism. The shared focus on unbundled service, so we're trying to deconstruct, I guess, legal issues and into smaller pieces to make them more manageable for the client and for us. Low cost, obviously. We're trying to make it as affordable as possible. And we're big on fixed rate because that provides cost certainty and certainty around scope for both the client and the legal service provider, such that they can move on and so forth. And I'll just say quickly that having a limited scope and a well-defined scope is helpful for sure, but also it presents certain difficulties because if the client needs more than the scope provides, or they expected something different than what we offer them, you don't have the same options as you might if you're charging by the hour, of course, where you might tell the client, well, okay, I can do that extra thing for you or that other thing for you, but it's going to cost you such and such an amount, right? And so it's we try and draw a bright line around the legal issue being served, and hopefully both the legal service provider and the client are happy about it at the end of the day. Both these programs, or all of these programs, prioritize local community-based services and promote culturally safe practices and environments wherever possible. We try and root these services in community while realizing that many problems have a sort of a local angle or flavor to them, and context is important to any legal problem. And yeah, we rely on continuous assessment of user feedback, always critical and laudatory, and yeah, and then our user feedback informs our continuous refinement of our systems. So that's the approach that's common to each of these programs, and I'm happy to talk about a bit more about them maybe in the question period. Thanks, David.
Thanks, James.
Okay, we got it. Hi, everyone. Katherine and I are so pleased to be here to talk about the service that we provide and the research that informed it. So to start off with our organization, the Advocacy Centre for Tenants Ontario is a specialty housing legal clinic providing, supporting and advancing the rights of low-income tenants in Ontario. And ACTO's mandate involves providing legal advice and representation, law reform, community organizing, and education. ACTO is perhaps best known for our Tenant Duty Council program, providing brief legal advice for tenants who come to the Landlord and Tenant Board without representation. So a little bit of background on our program, which is called Your Way Forward. So in response to a 30% increase of gender-based violence during the COVID-19 pandemic, the Department of Justice provided project funding to 9 legal clinics across Ontario. So this is a collaborative initiative called Your Way Forward, and across different clinics provides family, criminal, and housing legal support to survivors. Currently, our program is funded by the Law Foundation of Ontario. So for us at ACTO, because our goal was to expand housing legal services for survivors, we first needed to understand survivors' journey, long-term housing journey across Ontario, to identify gaps and ultimately create a new service specifically designed for survivors. So to do this, our predecessors in our roles completed a research project. This involved 80 interviews with service providers and survivors, 168 survey responses from service providers and survivors, and a policy roundtable event attended by various stakeholders, including survivors. And as a provincial legal clinic, it was important to hear stories from all over Ontario, so we did our best to ensure geographic spread. This research project culminated in our report, which is entitled The Journey to Housing Stability for Survivors of Gender-Based Violence, and that launched last June 2025. And so at that point, our specialized service, which is informed by the research, fully launched.
So what you're looking at now is the housing continuum, and the housing continuum is a tool used by housing policymakers to describe all the different types of housing available. The idea is that people could move through it step by step, starting with homelessness and eventually becoming homeowners. We didn't focus on home ownership in our research because it's no longer a realistic option for most low-income renters. Our research shows that the housing system doesn't work like a smooth path or ladder. It's more like a set of gears in a machine. If one part gets stuck, then the whole system can break down. Our research found that survivors' experience with housing do not follow a straightforward path along this continuum. Instead, they experience frequent setbacks, mirroring the loss of control, agency, and choice that characterize the violence they fled. These setbacks include living in situations of hidden homelessness, including couch surfing, shelters offering above capacity and with increases chances of violence. Extremely limited supply of transitional housing, especially in northern and rural communities. Very long wait times for supportive housing and no specialized supportive housing in Ontario for survivors of gender-based violence. Inadequate and limited supplies of social housing and long wait terms despite special priority program status. Little to no affordable housing left in Ontario, and when trying to access market housing, survivors face many issues like struggling to pay rent, further exploitation, and discrimination. Realizing the right to safe, affordable, and stable housing is critical for recovery, autonomy, and protection against further harm. When we asked participants to talk about the common rental issues faced by renters experiencing gender-based violence, participants found the following issues occurred when a survivor was still living with the person causing harm or even after they left the person causing harm and started living by themselves. The issues they mentioned are the 8 listed here: rental arrears, damages, inadequate housing, limited tenant protections, threats of eviction, sexual violence by their landlord, roommate abuse, and discrimination. I don't have enough time to go into specifics about those issues, but the number one, which is probably not surprising, it would be rental arrears. It's the most common issue leading to survivors being evicted from their units. This can happen mostly because of financial abuse is occurring, which includes the person causing harm stealing money, keeping the survivor's money, or telling them how they can spend money. Survivors also face arrears issues even after they left if they didn't properly terminate their interest in their joint tenancy. When survivors face this carousel of rental issues, they will often choose to leave the unit rather than stay and fight the legal issues. We're also consistent with our research, they're also unaware of their tenant rights or that housing legal services even exist. In Ontario, housing legal protections are limited, and there are issues with the Residential Tenancies Act. For example, just 2 most common examples are that it's very difficult to remove the person causing harm from a lease if there's a joint tenancy. And while there are protections for a survivor to leave a unit, it's called an N15 in a statement, that has very limited use within the affordability crisis. It's very difficult to find somewhere else to live within 28 days. And survivors are often penalized if they're leaving in a trauma response and aren't able to fill out the forms properly, and then they're still then on the hook on their lease.
So our research findings showed the complex relationship between violence, housing instability, and justice system failures, which create persistent barriers to safety and recovery for survivors. Throughout the interviews, survivors told us what they needed: to be believed, to be treated with fairness and dignity, and to have real equitable access to justice and to safe, stable housing. This insight from survivors led to the design of our service, which is the first of its kind in Canada. And the foundation of this service is self-determination. And I wanted to share this one quote that I think really captures what we mean by this. So this survivor said, "The last thing you want is there to be additional hoops you have to jump through. It's silly. Can you just try to set it up in a way where we have as much agency and choice as possible, and then we can decide what we want to do?"
So the survivors we spoke to often had limited awareness of their rights and were faced with overburdened legal clinics, eligibility hurdles, and re-traumatizing experiences at the Landlord and Tenant Board. The legal system often lacks trauma-informed practices, contributing to further harm. Our service aims to implement the services survivors talked about wanting and to correct the difficult experiences they disclosed having within the legal system. This resulted in a service that incorporates these 8 different aspects. We can provide legal advice and representation for tenants navigating housing legal issues due to gender-based violence. This work can involve preventing evictions at the landlord and tenant board, applying or appealing for social housing priority status, exploring a survivor's options to leave or stay, or supporting a survivor with a tenant application to assert their rights. In our research, we heard that the absence of choice was a central issue, and in our legal work, the goal is to provide accessible legal advice that empowers survivors to make the best decisions for themselves within the legal options available to them.
So the legal professionals that we interviewed reported greater success in working with survivors when they had a social worker on their team to assist with various wraparound support needs, including crisis de-escalation, system navigating, and supportive counseling. However, the majority of services reported that they did not have a social worker on staff. So our service provides this wraparound support with the social work component. So I provide support navigating the legal system emotionally, and also risk management, ongoing safety planning, case management, counseling, and referrals to broader support networks. Survivors were clear that one of the biggest challenges they faced when they sought legal help was that legal professionals lacked compassion or did not seem to understand their situation. At the same time, the legal professionals that we interviewed reported that they did not have access to proper training on how to work with survivors and to address their unique needs. So it's clear that there's a gap and that legal services need to provide this trauma-informed care and provided by trained and competent staff. So our service is trauma-informed, which of course incorporates a lot of different things, but I want to just highlight a few general practices that we have that were specifically mentioned by survivors we interviewed. So we provide as much flexibility as we can, including providing longer appointments, especially during an intake, to allow survivors to tell their story in their way. This is crucial in cultivating trust and building rapport and increasing their overall sense of safety. It also means allowing space for survivors to share information that may not seem legally relevant, but may be hugely important for them to share emotionally. Finally, we aim to have clear and thoughtful communication that does not inadvertently cause a survivor to feel judged or doubted. This is particularly important as they are often navigating a system that does doubt them. Being able to provide a space of belief and empowerment within an otherwise really re-traumatizing process can significantly help lighten their load and support their engagement in the legal process overall.
So we aim to remove barriers that survivors had come across, including waiving income eligibility rules and removing time limits to our services. We help no matter the survivor's immigration status, and we have free interpretation services available. This ensures that survivors have adequate access to justice. We also collaborate with our partners in family and criminal law through the broader Your Way Forward collector, as well as within the gender-based violence sector, including other provincial legal services for survivors that offer legal support outside of housing law, like the Barbara Schleifer Commemorative Clinic and Luke's Place.
So we continue to evaluate and inform our service based on data collection and survivor feedback. And a key goal of our research was that we could be replicated across the Ontario legal clinic system. The biggest barrier in our program is capacity. We have a provincial mandate, and there's one of Katherine and one of me. So through this goal of replication, we do case consults with different clinics across Ontario, and we've also consulted with one specific clinic that was able to create their own version of this service in their area, and we hope to do that more to create that regional expertise. And finally, our clinic, ACTO, engages in law reform to improve survivors' chances at achieving long-term housing stability. So thank you for your time. This was a really brief overview. I do encourage you, if you're interested, to look at our report. It can be found on our website, which is acto.ca. Thanks so much.
try? Okay. Oh. Okay. So, hi everyone. Bonjour à tous. Je suis Bérangère Desfonds. Je suis avocate pour Justice Pro Bono. Je suis ici pour vous présenter les partenariats médico-juridiques de Justice Pro Bono. L'objectif de la présentation d'aujourd'hui, c'est pas de revenir sur les définitions de qu'est-ce qu'un partenariat médico-juridique, mais c'est un peu de vous illustrer comment sur le terrain ça fonctionne, comment en fait on adresse aussi les commentaires des usagers du service et comment aussi on travaille en multidisciplinarité avec les différents intervenants du système de santé. Avant de rentrer un petit peu plus en détail là, sur le programme, quelques mots sur Justice Pro Bono, donc une organisation sans but lucratif fondée en 2008 qui a le but de répondre à des besoins juridiques en mobilisant la communauté juridique par le biais de différents programmes. Pour en nommer quelques-uns, le programme du Grand Nord, donc il a le but de desservir des populations qui sont un peu plus isolées par des services juridiques, donc c'est pour les populations du Nunavik. Il y a aussi des programmes comme Port 33, un programme en droit familial. Et donc, plus particulièrement, le programme de partenariat médico-juridique. Donc, en fait, c'est un peu de vous expliquer d'où est-ce qu'on part, les observations, ce qu'on a pu remarquer sur le terrain. Je vais vous donner plusieurs exemples de comment ces barrières-là se reflètent sur le terrain et pourquoi, en fait, là, on a pu bâtir ce programme-là. On a pu remarquer que dans les usagers, beaucoup des problèmes juridiques affectaient la santé. Donc, la question, c'est comment on peut adresser ça, comment on peut travailler pour pouvoir leur remédier à ces enjeux-là. Donc, on voyait, par exemple, beaucoup de gens qui avaient de la haute pression, puis en creusant un petit peu plus, on se rendait compte que ces gens-là étaient en attente d'une audience, qu'ils n'avaient pas d'avocat. Donc, c'est vraiment des enjeux qu'on a pu voir sur le terrain. On a vu aussi beaucoup de familles, par exemple, qui n'étaient pas en mesure de s'occuper d'enfants hospitalisés parce qu'ils avaient, par exemple, des dates de cours, parce qu'ils étaient un petit peu stressés par leur statut en immigration. Donc, c'était un petit peu difficile pour eux là, de pouvoir s'occuper des enfants hospitalisés dans les différents là, centres de soins. Puis, il y avait effectivement là, plusieurs barrières structurelles qui ne sont pas des nouveautés là, qui existent un peu partout. Mais ce qu'on a beaucoup remarqué, c'est qu'il y avait une crainte d'avoir accès à certains services juridiques, qu'il y avait une crainte de venir parler à certains avocats. Donc, ces barrières-là étaient quand même très difficiles pour nous là, d'offrir des services directement à ces gens-là. Soit les gens ne voulaient pas nécessairement venir nous voir ou ils avaient un peu là, une fatigue institutionnelle parce qu'ils avaient parlé déjà à d'autres avocats dans le passé. Donc, c'était un peu des observations là, qu'on a pu voir directement sur le terrain. Donc, comment on a pu un peu adresser ces observations-là, comment on a pu adresser ce qu'on appelle le gap. This one. Sorry. Donc, c'est par le modèle qu'on a pu développer. Puis, comme j'ai précisé, ce modèle-là a été développé aussi en discutant directement avec les bénéficiaires du service, en parlant directement aussi avec les travailleurs et travailleuses sociales là, sur les centres de soins. Donc, ça n'a pas été seulement bâti de l'extérieur, mais ça a été bâti là, sur le terrain et ça continue d'évoluer et de se bâtir en fonction là, des préoccupations qui sont soulevées tous les jours là, lors du programme. Donc, revenir un petit peu sur les partenariats médico-juridiques. Donc, qu'est-ce que c'est? Donc, c'est d'offrir des services juridiques de proximité directement dans les milieux de soins pour vraiment s'adresser aux déterminants sociaux de la santé. Donc, le programme de Justice Pro Bono des partenariats médico-juridiques, on est présent actuellement dans 3 centres de soins, donc l'hôpital de Montréal pour enfants, l'hôpital de Sainte-Justine et le CLSC de Parc-Extension depuis là, presque tout récemment. Et le fonctionnement. En fait, le fonctionnement, c'est que toutes les semaines, donc l'avocate de triage qui est moi, là, est présente directement dans les hôpitaux, dans les centres de soins. En fait, on a un bureau qui est dans le service social et on reçoit des références par les travailleurs et travailleuses sociales. et ça nous permet en fait un petit peu de venir adresser l'enjeu de la confiance à travers les avocats et le système de justice, parce que souvent, les travailleurs et travailleuses sociales sont présents lors des consultations juridiques. Ils expliquent beaucoup les services qu'on offre directement aux patients. Donc, il y a déjà une préparation un petit peu mentale là, pour les patients et les familles des patients qui viennent nous consulter là, dans les centres de soins. On a remarqué aussi, et c'est un des enjeux là, qu'on a pu adapter aussi en fonction du terrain, c'est qu'on fait maintenant des consultations beaucoup plus longues. Donc, on prend vraiment le temps sur les centres de soins de parler aux usagers. Donc, c'est des séances des fois qui peuvent prendre 3 heures parce que, bien évidemment, beaucoup de nos usagers ne parlent ni français ni anglais. Certaines personnes ont des enjeux de mobilité et il y a aussi des enjeux qui existent là, dans les hôpitaux pour enfants, c'est que la plupart des parents n'ont pas nécessairement accès à une garderie pour faire garder leur enfant pendant les consultations juridiques. Donc, c'est vraiment des aspects qu'on doit prendre en compte lorsqu'on propose un service. Donc, des consultations plus longues, de prendre le temps avec des interprètes. Et beaucoup de nos usagers, de patients et des familles n'ont pas non plus nécessairement accès à de la technologie. Donc, plusieurs personnes viennent nous voir avec des papiers, ne savent pas nécessairement comment utiliser là, certains logiciels. Donc, ça rajoute un peu une complexité. Donc, en prenant le temps sur les centres de soins de nous assurer déjà que la personne comprend bien, qu'on est bien compris, c'est vraiment quelque chose là qui a été bénéfique et où on a beaucoup de rétroactions positives quand même là, des intervenants et des gens directement. Un autre aspect aussi là, qui est quand même intéressant de mentionner, c'est qu'en étant directement sur les points de service, les centres de soins, on est en mesure de partager les ressources avec ces centres de soins-là. Donc, on parle tout ce qui est traduction, on est en mesure d'utiliser et de partager là, leur système de traduction. Donc, ça, c'est quand même quelque chose qui est très bénéfique pour nous. Et on est bien évidemment en mesure aussi de partager, là, comme c'est des lieux qui sont facilement accessibles, donc pour tous les gens qui sont à mobilité réduite aussi, ça leur permet d'avoir accès à ces lieux-là. Parce que c'est des barrières là, qui ont été nommées par les usagers, parfois lorsqu'ils vont rencontrer des avocats, parfois c'est pas nécessairement tous les bureaux qui sont adaptés. Donc, en étant directement sur le centre de soins, ça permet là, d'avoir accès directement à un avocat sans ces barrières-là. Donc, plus précisément, là, rapidement, sur les 3 activités principales du partenariat médico-juridique. Donc, on offre des consultations et de l'accompagnement juridique là, pour les patients et familles des patients directement dans les centres de soins. Donc, ça, c'est un peu le plus grand aspect là, du programme. Ensuite, on offre beaucoup de conférences ou d'entraînement un petit peu là, pour les travailleurs sociaux et les médecins, pour les sensibiliser aux enjeux du système juridique, pour les former aussi sur parfois lorsqu'il y a des changements de loi. Donc, on fait un petit peu de formation, de mise à jour aussi là, des connaissances pour permettre justement à ces gens-là de nous assister en reconnaissant certains problèmes juridiques et en nous référant là, les patients. Et lorsqu'il y a des enjeux plus systémiques aussi, là, donc en participant à des groupes pour pouvoir le faire avancer là, peut-être certains aspects. Donc, annuellement, là, c'est environ 60 familles là, qu'on est en mesure d'assister là, sur les centres de soins. Donc, au niveau de l'impact, donc ça, c'est vraiment des mesures là, qui nous ont été rapportées par les usagers eux-mêmes en parlant aux travailleurs sociaux, en parlant aux médecins aussi. Donc, c'est vraiment les données là, du terrain. Donc, on a eu beaucoup là, de gens qui nous ont mentionné effectivement que ça avait un impact positif sur leur santé. Donc, pour revenir un petit peu à l'illustration là, de la personne qui avait de la haute pression, en ayant accès à un avocat, en ayant accès de façon rapide à un avocat qui a compris sa situation, on a pu le référer. Cette personne-là a pu avoir un avocat Pro Bono qui a pu prendre en charge son dossier. Donc, c'est sûr que ça a eu un impact direct là, sur son état de santé, sur sa pression. Bien évidemment, bon, l'accès à la justice en étant directement sur les points de service, mais souvent en étant aussi la porte d'entrée pour plusieurs usagers là, qui n'ont jamais eu accès vraiment à la justice, soit pour des raisons de coût, Donc, on leur permet vraiment d'être cette porte d'entrée-là directement dans les centres de soins, sans qu'il y ait nécessairement besoin de se déplacer ailleurs ou de faire des recherches eux-mêmes là, pour accéder. Approche préventive, donc on nous a beaucoup mentionné, surtout de la part des travailleurs sociaux, qu'ils appréciaient qu'on soit présent sur les centres de soins pour pouvoir venir nous poser certaines questions. Donc, c'est vraiment quelque chose qui est fait en amont par les travailleurs sociaux pour mieux comprendre une situation juridique, pour mieux, après ça, là, faire de la référence. Bien évidemment, là, réduire la pression sur le système de santé, parce que moi, je ne suis pas travailleuse sociale, même si on fait certaines formations un petit peu pour être sensibilisé à certains enjeux, je ne suis pas en mesure de faire l'accompagnement qu'un travailleur ou une travailleuse sociale peut faire. Même chose pour les travailleurs sociaux, ce n'est pas non plus des avocats. Donc, au lieu, par exemple, qu'une travailleuse sociale commence à faire des recherches juridiques pour mieux accompagner le patient ou la patiente, de venir directement référer le dossier à un avocat ou de parler à un avocat, ça lui permet un petit peu mieux de se concentrer sur ses tâches et de rapidement, là, pour la personne, pouvoir accès à un avocat ou une avocate. Puis rapidement, là, sur le empowerment, on a eu beaucoup de commentaires positifs sur des gens, par exemple, qui n'avaient jamais nécessairement parlé à des avocats ou qui ont déjà parlé à des avocats, mais qui étaient très anxieux ou stressés en raison des mauvaises expériences. Mais en leur fournissant, par exemple, certaines informations qui n'étaient pas accessibles pour eux, ils ont vraiment pu développer ce sens d'empowerment. Puis je vais vous donner un exemple en particulier d'une dame qui était dans une instance là, de divorce où il y avait son ex-conjoint qui ne respectait pas nécessairement le jugement et qui ne connaissait pas vraiment ses droits, qu'est-ce qui se passe, qu'est-ce qu'on peut faire avec ça, qui était un petit peu, pas nécessairement passif par rapport à la situation, mais qui ne connaissait pas ses options. Puis juste lors d'une consultation, on a pu, avec elle, là, vraiment détailler ses options, voir qu'est-ce qui était possible pour elle. Puis suivant la consultation, elle nous a vraiment remercié en disant « Ah, il y a ces options-là qui existent, j'ai envie de me mobiliser, j'ai envie d'aller trouver un avocat, j'ai envie de pouvoir là, faire respecter mes droits. » Donc ça, c'est vraiment quelque chose là, qui a pu être mesuré là, pour ça. Donc, je vais accélérer un petit peu. Donc, au niveau là, des barrières qui restent, c'est quelque chose là, qui est bien évidemment présent dans plusieurs programmes, là, qui n'est pas spécifique aux partenariats médico-juridiques. Donc, tout ce qui est au niveau là, du financement, les barrières aussi qui vont demeurer au niveau là, de la confiance envers le système de justice, les enjeux aussi au niveau de la confidentialité parfois, où il y a de partage d'informations entre des avocats, entre les médecins. Donc, c'est tous ces enjeux-là aussi là, qui restent un petit peu à adresser. Puis au niveau là, bon, du data gaps, effectivement, ce qui nous manque un petit peu de notre côté, c'est plus des données qualitatives. Donc, comment on vient qualifier un petit peu la situation des usagers sur le terrain, comment on est en mesure de parler à ces gens-là, parce que souvent, ils ont la peur un petit peu là, de parler à des gens extérieurs, ils ont peur un petit peu de parler de leur expérience, il y a beaucoup de barrières d'enjeux au niveau de la langue aussi. Donc ça, au niveau là, des données un petit peu manquantes, là, c'est un enjeu qui demeure. Et brièvement, il reste quelques 2 minutes. Je vais un petit peu là sur qu'est-ce qui est le futur, qu'est-ce qui est possible de faire, les réponses. Donc, comme j'ai mentionné, c'est quand même des défis qui sont toujours présents dans le cadre là, du programme de partenariat juridique, mais on essaie vraiment de continuer de bâtir une relation interdisciplinaire entre les travailleurs sociaux, médecins, donc en leur parlant, en essayant de faire de la sensibilisation, en essayant de faire des formations, en les incluant dans des groupes systémiques, on est en mesure un petit peu plus de bâtir cette relation de confiance, de clarifier aussi les rôles, parce que des fois, le rôle entre un travailleur social, avocat, médecin, ça peut venir un peu se chevaucher, là, où il y a une perception pour les patients que ça se chevauche. Donc, ça va être important là, de continuer à clarifier les rôles professionnels, bien évidemment, là, de venir renforcer les données. Et peut-être là, pour le futur là, du programme Justice Pro Bono, donc ça serait un petit peu d'expandre le programme à l'extérieur de Montréal, dans d'autres types de soins, dans d'autres, par exemple au niveau des soins palliatifs, c'est quelque chose qui serait intéressant de faire, d'inclure aussi d'autres professionnels comme des notaires aussi, Mais bien évidemment, tout ça là, va requérir bien évidemment du support institutionnel et du financement et une reconnaissance formelle. Donc, merci beaucoup.
Merci.
Hello, everyone. I am here to discuss empowering people-centered justice through the lens of our program, which is the Black Justice Navigator program with Jack U. Combit, an organization based here in Ottawa that has supported Black communities for the last 25 years. Our mission is to continue supporting individuals and families of African, Caribbean, and Canadian descent, and any other equity-deserving individuals through community partnership and programming that results in successful economic and civic participation in Canadian society. Before I get into this, our organization was contracted by the Canadian Black Justice Strategy, which is a strategy that is set to address the overrepresentation of Black individuals in the justice system. So this is what led to the launch of our program earlier this year, and part of why we're here as well. So I wanted to get into what people-centered justice means and how we see that in our organization. And people-centered justice starts with the legal needs of the person and not the structure of the institution. It asks, what does this person need to resolve their problem, and how do we remove the barriers between them and that outcome? So for us, we think about putting people first. The African Canadian Black community is very community-oriented. We are very family-oriented groups of people, so we always think about putting people first and designing services around how people experience any issues in the community. Specifically in our program, how people experience legal problems, and not about how institutions basically deliver legal services to individuals. So for us, that means accessible language, flexible locations, and we go by the no wrong door approach. So even if we can't help with a specific issue, we always find ways to connect people and issue those warm transfers between organizations and other culturally competent services. We focus on solving problems and not processing cases. In the not-for-profit sector, unfortunately, there's a lot of numbers, there's a lot of thought processes of closing cases and so on and so forth, but we really want to support the people and not the problems, not just the case numbers that come in. So we focus on resolving the underlying issues which lead to incarceration, which is housing, income, safety, family, and so on and so forth. And we have, over the last 25 years, tried to build trust, community trust through presence. So that's showing up to community events, that's just being a trusted voice in our community. And we realized that because of the overrepresentation of Black people in the justice system, people who have been failed by this system don't trust institutions. So we are aiming to be that middleman who kind of bridges the gap between the justice system and the community. So we try to do that through consistent, culturally grounded, and community-embedded relationships. So the Canadian Black Justice Strategy is operating under 5 pillars. And this matters in our community because the social factors that drive Black involvement in the justice system are well documented. For African and Caribbean communities in Canada, these determinants are compounded by anti-Black racism, immigration barriers, unrecognized credentials, and the intergenerational effects of displacement and discrimination, especially for those who are in the community who have been here for generations through the transatlantic slave trade. So these 5 pillars basically say that if the government of Canada and if the community of Canada at large is able to address some of these issues, we will see a reduced overrepresentation of Black people in the justice system. One of these is income and employment. Black Canadians face lower incomes and higher unemployment. This is both for people who have been here for generations and people who have recently immigrated. If you know anyone who has recently immigrated, it's a really, really long process. And a lot of times people with their credentials are often unrecognized, which pushes people into doing under-the-table work or different types of jobs that don't bring in steady income and can put them at risk for legal involvement. Another one is housing stability that some of my panel members have also expounded on. Black renters face documented discrimination with refused tenancy, inflated rent, withheld deposits. Overcrowding is also a huge issue in the African Caribbean households and is directly tied to justice system contact. Education is another pillar. Black history is absent from most Canadian curriculum. Anti-Black racism in school drives higher suspensions and lower graduation rates. And actually, there's been studies that show that there is a pipeline directly from school to prison for a lot of Black male individuals specifically. Mental health. Culturally appropriate services are inaccessible to most African and Caribbean community members. There's a lot of stigma. There's language and cultural barriers, and there's mistrust rooted in histories of medical racism, and that leaves needs unmet and also leads to criminalization. And lastly, immigration and settlement. Many people who are navigating the justice system while managing immigration status, language barriers, and settlement stress. These intersecting pressures are rarely recognized in standard legal models, and also interactions with the criminal justice system can lead to precarious immigration and settlement issues. So losing residency or being deported, things like that come out of that. And for us, when we are thinking about the people-centered approach and making sure that we are serving people in our community and not just numbers, we really focus on cultural grounding. So our program is built on, we look like the people that we serve. We are part of the community. We speak the languages. We have that trust with each other. We have the shared experience. We understand what it's like to be Black. We know what it's like to be Black facing legal discrimination. And so that shared experience really helps to break down some of the barriers with our clients, and it helps to uplift the community. We also try to have an integrated and holistic approach, because legal problems rarely come on their own. So somebody who is already facing a criminal charge may also be facing an eviction, a custody dispute, mental health crisis, immigration barriers. So we try to address the full picture. And this program was designed by the community. So in 2023, when our organization was contracted to go into the community and see what the Black community thinks about the justice system, we really focused on bringing different members of the community from different corners to really strengthen our community consultation. So members of the community told us what they needed. They need people who look like them, who speak their languages, who understand their realities. And one of the biggest issues too for our community is a lot of our community members can only afford legal aid. And unfortunately, it is a very white-centered institution. And so people who don't understand the realities of what they're facing. Of course, your Blackness is very centered towards your criminal case. You're not just going to see a judge. You're not just going through the criminal system, you're also going through the criminal system and facing racial discrimination or instability. So we really try to design the program for the community and by the community, and we continue to reach into the community to ensure that we are doing what we're supposed to be doing and providing culturally responsive services. So I had talked earlier about the social determinants of, sorry, I already talked about this. My bad. So a little bit more about our program. We support any Black adults who are involved in the criminal justice system, either who are just going through the criminal justice system or who are reintegrating into the community after being in prison. So how we do this is we have trained Black justice navigators who support people through court, bail, probation, parole, and reintegration. We try to provide plain language information on rights and what to expect at each stage of the process of the criminal justice system. We provide one-on-one support and group workshops, which we deliver in English, French, and any other community languages as needed. And we provide referrals to legal aid, housing, mental health, employment, and community services through one relationship. So we really try to limit sending clients on a wild goose chase to find different organizations that can support them. And we try to kind of be the hub of services and providing support. So if somebody comes to us, we try to provide that warm transfer to another agency if they need other services outside of our agency. So those we serve, anybody who self-identifies as a Black individual, anybody 18 and older, any gender is welcome, anybody who has been charged, convicted on bail, probation, or parole, and we are open to anybody with any type of immigration status, so newcomers, refugees, permanent residents, citizens, and so on. Again, I touched on this earlier, but we also offer reintegration support, so that's support through parole and post-release period, access to housing, employment, and mental health services, help navigating community supports and social services, life skills and social reintegration planning, referrals to legal aid and other culturally responsive programming, and just ongoing one-on-one navigation. So as I touched on earlier as well, you know, we try to address all the different needs that people come in with. Again, if somebody's going through the legal system, they're probably also dealing with a myriad of other issues. So a criminal charge can be accompanied by a housing crisis or family law matter or lost income. So being effective in helping people navigate the justice system really means approaching and addressing the full picture. So all types of criminal justice and civil and social legal issues are things that we participate in. And we also try to support through IRCAs, which are impact of race and culture assessments, which support Black individuals to see if their case was impacted because of their race. So if their sentencing was harsher because they were a Black person, we try to provide those services. That way we can reduce sentencing or also get some type of support post-incarceration. So this is what we're expecting. Our program is still fairly new. We've been working on this since 2023, but every program under the CBJS is still fairly new this year. So we're hoping, as with time and as we're in the community, that we can help individuals in our community better understand their rights and justice processes, and that they're able to have increased confidence in the legal system and increased confidence in navigating the system. We hope to reduce barriers between Black residents and increase fair outcomes, and also stronger connections to housing, community, mental health, and employment, and also reduced repeat justice involvement through consistent support, which is something that we found to be a very big issue. Although Black people are less likely to reoffend, we are actually more likely to be provided with reintegration supports and supports that help when post-incarcerated. So, as I said, we are still in the early stages of our program delivery, and we what data that we think we would need as time goes on to advance this work would be local disaggregated data. So we want to know how are Black clients faring at bail, sentencing, and parole in Ottawa and nationally as well. We need data confirming what we see daily, so criminal justice involvement, coinciding with housing, civil, and law issues. We want to know how much those overlap. We would like to know a longitudinal comparison of outcomes for people who access navigation services versus those who did not, tracking community trust over time, a consistent measure of Black residents' confidence in the justice system, and the cost benefit of navigation programs. So how much does it cost? Because it's really all about money when it comes to funding, and how can we reduce the cost but also increase the services that we are providing? These are all essential for funding conversations in the next 10 years as we improve the strategy. Thank you very much for listening, and we hope to keep building evidence and actively seeking research participants, collaborations, and policy dialogue. And we require everybody's help in this room, out of this room, to support the Canadian Black Justice Strategy and to address systemic barriers that affect people in our community. Thank you.
Thanks so much, Dolapo, and all the presentations. I'm sure you all appreciate that they stuck absolutely to time. And now we do have, so thank you for that. It's not easy. So we do have a little bit of time for some questions or comments from the audience. If anyone has one, please take a mic and go ahead.
Thank you so much for these excellent presentations and overviews, all the programs and services that you're providing. I do have a question for Leah and Katherine. I'm wondering about, in your conversations with survivors, some of the research that you've done, if there's any recommendations for legislative changes around housing law that come from them. I know in British Columbia, if you're going to separate and you want a decision about both rental housing or property, that's an incredibly challenging decision to have made. You have to go all the way to Supreme Court. So that exasperates coercive control and intimate partner violence. So I'm wondering if there's any recommendations to address sort of the legal context of this that either of you have. Law changes. What do you think?
Yeah. Part of the report is 17 policy recommendations that are like all over the board. So I really encourage look at that. But a couple off the top of my head that we often speak to because they're kind of, declaring IPV an epidemic would be hugely important in providing funding and investment across legal and housing systems. In the housing system in particular, I think Katherine spoke to this super briefly, but we usually talk a little bit more about how crucial supportive and transitional housing is for survivors in their longer term journey towards stable housing. These services don't have any core stable funding, especially in northern and rural communities. We also speak to, like at the landlord and tenant board, the importance of having training for adjudicators to understand the impacts of violence in these situations. There's been, Katherine has experience of a case that the original iteration of this case at the landlord and tenant board, an adjudicator basically didn't want to hear anything about violence, was very dismissive and would cut off the client when they were trying to speak about it. So those are off the top of my head, just a few of the recommendations, but I encourage you to read them in full. Anything to add? No? Okay. Thank you.
Thank you very much. This is really inspiring just to see that, these big ideas of people-centered justice. It's actually seen them come to life across all the panels, so thank you for that. Question for Leah and Katherine and Bérangère aussi. What I found really compelling is the combination of social workers with lawyers. We also heard from Bérangère l'importance de diviser un peu les rôles, d'être clair, so the division of role. I'm just wondering, do you see maybe potential for trying to combine some of the roles, this kind of one relationship idea that maybe with some training and support, social workers could do some of the initial kind of sense making on legal problems, case intake, and then reduces maybe on costs and transaction costs and people, and then and going forward. And if I can sneak in a second question pour Bérangère, à quel point vous avez pu réussir à faire le mesurement ou collection des données par rapport aux impacts? Parce que impact impressionnant, mais plus facile dit que fait, je dirais. So how are you being able to do some of the measurement or data collection? So thank you.
Yeah, it's a great question. I think in our particular work, an advantage of working together is that survivors don't have to tell their story more than once. We're basically together all of the time. So your question in talking about social workers as providing like initial assessment, I think is definitely possible. I always, as a social worker, am really conscious of kind of staying in my lane legal-wise. I think there's like lots of information that I can give, but a lot of times my experience has been that people really want the advice portion. So that's where our collaborative work is really, really helpful.
Yeah, and just when we're doing it together, that I can focus on the legal needs, which is very rare, because when you're dealing with vulnerable populations, if you don't have a social worker with you, then as long as you're trauma-informed, you can do your job, but you're always going to miss something, and there's going to be something that sets a client off in their trauma response. And in our program, we have been fairly successful in not really having a difficult client. You go to all these legal trainings, how do you deal with a difficult client? They're in a trauma response. And so with the social worker, they're able to say when a lawyer is giving them bad news to manage that expectation. So while in theory, yes, just having the social worker do the initial intake would reduce costs, we've tried that in other systems where you have students just do the initial assessment. I think part of the reason our program works, even though we can't serve as many people as we would want to, is because of the collaboration between the two.
Oui, concernant les travailleurs sociaux et travailleurs sociales, déjà, je veux juste mentionner que c'est vraiment un apport pour mon travail d'avocate. C'est vraiment, sans ces gens-là, je ne serais pas en mesure de faire le travail que je fais. Donc, je veux quand même là, les remercier de pouvoir nous assister là-dedans. Bien sûr qu'on travaille sur des outils un petit peu de formation pour les travailleurs sociaux pour qu'ils soient en mesure de reconnaître certains problèmes juridiques, qu'ils soient en mesure de poser certaines questions spécifiques pour, par exemple, reconnaître qu'il y a un enjeu dans le logement. Donc, tu sais, je donne un exemple un peu concret d'une situation où il y a quelqu'un qui fait de l'asthme, donc il vient consulter pour un problème d'asthme. Donc, il y a, dans le processus, là, il rencontre une travailleuse sociale. Donc, en posant des questions un petit peu sur d'où vient le problème, comment la personne gère ce problème-là, est-ce qu'il y a des mesures en place à la maison, comment ça se passe le suivi là, de la condition à la maison, bien, on se rend compte qu'il y a des enjeux de moisissure dans le logement. Donc, à ce moment-là, nous, en formant un petit peu les travailleurs sociaux, en leur donnant des outils, bien, c'est un peu d'amener les travailleurs sociaux à faire le lien entre moisissure dans le logement, probablement un problème qui peut se régler là, au niveau là, juridique. Est-ce qu'il y a un enjeu avec le propriétaire? Donc, c'est un petit peu comment on peut les intégrer un petit peu dans le travail. C'est sûr que le but, c'est pas de faire des travailleurs sociaux des juristes non plus. C'est pas leur rôle non plus. Puis c'est pas effectivement, là, comme Katherine a pu le mentionner, c'est pas aussi mon rôle en tant qu'avocate de faire du travail social. Donc, mais oui, c'est toujours à définir, c'est toujours quelque chose qui se travaille, qui se discute et qui est effectivement là, important dans l'avenir de pouvoir trouver un juste milieu entre ces enjeux-là. Peut-être pour répondre à la question sur les données. C'est sûr que, comme c'est beaucoup collecté directement en parlant sur les usagers. C'est quand même des données qui sont très, très, très difficiles à récolter, comme j'ai pu le mentionner. Par contre, on a vraiment des bons partenariats avec les hôpitaux, les travailleurs sociaux et les médecins. Donc, on est en mesure de leur poser des questions. C'est sûr que ce n'est pas nécessairement des questionnaires déterminés. C'est sûr que, donc, c'est plus au niveau là, du feedback qu'on a des milieux hospitaliers, puis de l'impact qu'on peut observer aussi, ce que les gens nous disent, sur des suivis des fois qu'on fait là, quelques mois ou quelques semaines après là, les consultations pour voir un petit peu l'évolution. Mais oui, on a effectivement un besoin là, au niveau là, des données qualitatives pour nous permettre un petit peu plus de structurer et va nous permettre aussi d'étendre le programme là, par la suite.
I'm really sorry to say that we're out of time. If we'd had more time, I think it would have been interesting to hear more from everybody about how within the programs, whether you've been able to build in the data collection sort of mechanisms to then measure the impact. You listed a number of things you're trying to map for your program, Dolapo, and everybody has mentioned things, and whether you got in the funding, you got funding to do that, whether you got help to do that sort of thing. So those are really important questions which we'll just have to let sit out there, because of course we've got the Minister of Justice and Justice Karakatsanis. Doing the next session is a fireside chat or a fan side chat, given the lovely conditions we have, which is in a different room, I believe. Let me just, I had it and then I lost it. Yes, it's back in the John McRae Auditorium starting in about 5 minutes, okay? So I'd ask you to just, before you leave, join with me in thanking the panel.